good afternoon, and welcome to today's virtual CLE, The Rise of Reasonable Cybersecurity, co-presented by Albany Law School's online programming, the Center for Internet Security, and Dorff, Nelson, and Zouderer. I'm Tom Rosenberger, Assistant Dean for Online Programs here at Albany Law School. This program is the second of Albany Law's ongoing CLE series on cybersecurity, privacy, and data protection, a critically important and rapidly evolving landscape of issues and opportunities. This series underscores our commitment to building a global online community that offers innovative and accessible programming for lawyers and other professionals whose work puts them at the intersection of technology, law, and business. We're offering a slate of programs on topics ranging from AI risk assessment, regulation, boardroom readiness, and Fourth Amendment concerns in relation to cybersecurity, privacy, and data protection. Each program includes expert speakers who are practitioner faculty in our online degree and certificate programs in cybersecurity and data privacy, as well as other notable experts from the field. Programs in this series will satisfy the New York State Bar Association's cybersecurity CLE requirement, and we invite all of you to consider registering for our upcoming programs. I'll place a link in the chat momentarily. I have just a few additional housekeeping items before we get started. This webinar is being recorded and will be posted publicly. However, CLE credit is only available for those who are in real-time attendance and capture the code word, which will be announced at some point during the program. Attendees seeking CLE will need to return within 24 hours the fillable PDF that my colleague Lisa Rivage provided to you via email. Today's agenda is quite full. However, the speakers welcome questions via the Q&A panel, and will seek to reserve some Q&A time at the end of our hour together. At the conclusion of today's program, we ask that you please complete the evaluation form to let us know how we can continue to improve our offerings. And we are already thinking about our 26-27 series, so please provide us with topics that would be of interest to you. Without further ado, it is my privilege to introduce today's moderator. Chirag Arora is an esteemed cybersecurity executive advisor and CISO based in New York. He has garnered numerous awards and accolades for his exemplary leadership and expertise in fortifying cybersecurity programs for global enterprises. Chirag?
Thank you, Tom. Good afternoon, everybody. As Tom introduced already, about my background, I'm Chirag Arora. I will be moderating today's session, as well as I'll cover some topics as well from panel perspective. So how are we going to move the slide deck? Tom, are you going to move it, or can I get the control?
Yep, I'll give you control.
Please, thank you. Thank you.
You should be able to, Chirag.
No, not yet. I only see the Albany Law School logo on the screen right now.
You don't have the share button?
Oh, you want me to share it? Okay, just allow me a second. I am.
Chirag, I'm happy to drive the slides if that makes things easier for you.
No, it's okay. I got it. Just only one more second. That's it. Thank you for offering. Please let me know if you're able to see the screen. Everybody good? Okay, perfect. Thanks, everybody. So today's topic is reasonable security. I'm going to quickly move on to the agenda for today. We'll start with introductions. Then we'll go on to the standard of care. Then around reasonable security, how the evolution of federal cybersecurity law is, we want to highlight that. Talk about state data privacy overview. And then some of the states that have been leading the way, we'll go over that. CIS has been doing a lot of work. Like I personally have been working with CIS team for almost 6 months right now. We have done multiple, sessions and multiple kind of tasks which would actually help the cybersecurity community from meeting the reasonableness standard or having the understanding of the reasonableness. A lot of times, lawyers are able to understand fairly quickly, whereas if you look at CISOs, they don't come from the law background. So for them to understand and then be able to effectively communicate with their general counsel, this has helped them a lot. I have had very positive feedback from multiple CISOs that this initiative from CIS standpoint has really helped them understand, navigate their way through their leadership. And we are hoping today that you'll be able to learn from this session the same thing and be able to then share your thoughts, your ideas with your CISOs and your senior leadership team as well. So we'll go over certain, over CIS controls and then how CIS controls are actually helping organizations meet a reasonable security. And then we'll open it up for questions. So with that said, I'm going to now pass it on to the panelists, starting with Tony for his introduction. Tony, please.
Thank you, Chirag, and thanks to the audience for joining us today. Yeah, just very briefly. So I'm approaching, I think, close to 48 years now in cybersecurity. The first 34 was at the National Security Agency, starting in the late 1970s, and I've spent my life in the business of vulnerability analysis. That is looking at, for the purpose of defense, looking for flaws in systems, software, protocols, et cetera. And really the last third of my career has been, how do we translate that into action? How do we take our understanding about technology, business use of technology, the skill and tradecraft of bad guys, and translate it into positive, constructive things that we could do about it? And that's really part of the sort of comic book origin story of the CIS controls and a lot of the best practice work out of CIS. So we're very excited to be a part of this activity. A few years ago, we started to shift our thinking from, what's the right technical answer to how do we blend together, I think Tom said in his introduction, technology, law, and business. And I think that's a good way to frame it. That is, we have a history of sort of having good ideas in technology and security that never get implemented for a variety of reasons, which almost always have to do with incentives, business, and the way people view the cybersecurity problem. So that's why we undertook this activity to work with some of the folks here on the call and then a broad community to help define this notion of reasonableness as seen in cybersecurity. So with that, I'm happy to turn it back to you, Chirag, and thank you for the time.
Thank you, Tony. Thank you for the introduction. Professor Haynes.
Good morning, everyone, and thank you so much for attending this presentation. I have been involved in the cybersecurity space for over 30 years now, not quite as long as Tony, but still some time. And I've seen it from both the technical IT perspective as a computer scientist and network security engineer, and now from a law and policy perspective as a lawyer. And as Tony indicated, this issue of what standard of care is reasonable is at heart and center of a lot of pain points for organizations, both from the C-suite, the CEO side of the house, as well as from the general counsel, legal side of the house. So I'm very excited about the opportunity to shed some light on this hard issue today.
Thank you, Professor Haynes. So real quick about my background, Tom already explained, I pretty much have a CISO background. Along with the CISO background, I went to Albany Law School, did my JD between 2020 and 2023. I have been associated with a law firm. I have done CISO work as well as advised a lot of clients around incident response, CIS control framework, NIST frameworks, and so forth. From currently where I am more into a CISO plus law. I do community effort through CIS. I'm a CIS ambassador. Along with that, I chair the GlobalCISO Leadership Foundation. So that's my background. I'm going to now pass it on to Kirk. Kirk, please go ahead. Kirk, you're muted.
Thank you, Chirag.
Thank you.
Kirk Herath. I am the chair of CyberOhio, which is a private sector advisory board for the state of Ohio, particularly the executive branch. I also have had the pleasure for the last 3.5 years of being Governor Mike DeWine's cybersecurity strategic advisor. And in that role, I've helped to reorganize the state's cybersecurity functions, bring risk governance to the state, Prior to that, I spent 32 years at Nationwide Insurance in a technology legal role. In the last 25 years, I was the privacy officer, and I ran the cybersecurity legal functions around incident response. Like Antony, I've got about 30 years of experience in cybersecurity, privacy law, data law, as well as sort of broad technology. And I look forward to the discussion today. I've had the pleasure of speaking with Tony several times, and I always enjoy his presentations too.
Thank you, Kirk. So that's our panel today. So as Tom mentioned, please feel free to ask any questions. We will take the questions at the end. So to start with, we would like to clarify what standard of care is, what duty of care is, and then go over reasonableness and proportionality. So I would request Professor Haynes to start and share his thoughts around standard of care.
Thank you, Chirag. So as I mentioned earlier, I've been involved in this at some time. And so now as a professor of law at Albany Law School, and also as a partner at Dorff, Nelson, and Zotterer, I've been thinking about the standard of care. And so what I've been arguing is that the standard of care is actually something that is effectively a tripartite standard. And so the way that I see it is that you have a strategic layer, which is the NIST cybersecurity framework, a tactical layer, which are the Center for Internet Security Controls, and then kind of a governance procedures layer, which is ISO 27001. And then I see the Federal Trade Commission and the regulators as implementing the effective tripartite standard. So here on this slide, I think it's slide 8 in the presentation, we're asking the question of why do you even need a standard of care? So we assume that we have this tripartite standard, and the answer is very simple. It gives you a clear guidance for whether or not you're going to face legal liability in court for negligence. What is it when you're not being adequate in your measures? And this is not simply a technical question of did you have a firewall secured or an intrusion detection system or virus scanners. It's a question of processes, procedures, peoples. And I think that the answer is, as I've mentioned earlier, just tripartite standard. And so the way that I would begin defining the standard of care is by using that standard. Now you're going to see in the slide deck, we're going in a slightly different direction by focusing on the more tactical layer around the CIS controls. And if you could only do just one thing, I would say that's a pretty good starting point for defining exactly what is standard of care. Chirag, would you go to the next slide, please? Yeah, so this duty of care is very important. The Federal Trade Commission has a number of enforcement actions in the data security space. Just in May of this year, there was a settlement with GoDaddy around this. And if you read that GoDaddy FTC settlement, it kind of gives you an idea for what is the standard for reasonable or adequate cybersecurity. And the point that I take from these enforcement actions is that when the regulators show up, they measure you against an implicit benchmark or framework. And so in the FTC enforcement actions, the implicit framework is the information security program, which has to be documented and maintained and periodically evaluated. And so that's the yardstick you use in court for later use. But throughout all of the decisions, the FTC will point to, again, ISO, CIS, and the NIST CSF frameworks here. So again, as we note here, the duty of care includes both technical and organizational measures, compliant with various standards here, and you want to make certain that you're mitigating foreseeable cybersecurity risks and vulnerabilities, and that you respond promptly. And so what this means then for you as either a practitioner from a legal point of view or from an IT point of view or organizational point of view is that you really need to write down what you're doing from a cybersecurity and data privacy perspective, And make certain you have independent verification, so some kind of third-party auditor to verify what you're doing here. And you've got to actually make certain that you tie in, signatures to your governance program, that you plan for exceptions, and that you are able to have kind of a standardized process for dealing with incidences. Chirag, next slide, please. And so we come to these notions of reasonableness and proportionality. So throughout the very spare amount of court cases and looking at the much more voluminous FTC enforcement actions, we come down to these two key ideas of reasonableness and proportionality. And so later on, my co-panelists will talk about the state level enforcement, the regulations around this and the statutes. And so you'll see these principles of reasonableness and proportionality as being more fully developed at the state level, and thinking about how to actually get around what is reasonable and what is proportional for the standard of care. And so for reasonableness here, you've got to conduct an assessment. You have to make certain that you provide clear expectations for other parties in your contractual relationships. And you're thinking, what does a reasonable person do for securing your infrastructure, your framework, your organization? And if for proportionality, we can see a key hook for this idea as coming from the European Union's various regulations and statutes, such as the GDPR and the 2024 EU AI Act. Give you some ideas of what's proportional in this various area here. So these are all very important ideas. And as we go forward, the key ideas that we saw in that GoYati case, again, I encourage you to read the May 2025 settlement here, are going to be very important in helping to ensure that you've met what is considered reasonable or adequate cybersecurity. That's it, Chirag.
Thank you, Professor Haynes. So, with those slides around standard of care, duty of care, reasonableness and proportionality, we really want to give you a view of what care should be and where it is heading. Now, where it is heading is basically there are multiple laws that are kind of coming and it's kind of evolving a lot. And what we want to do is we want to now go over how federal cybersecurity law is evolving and then talk about state data privacy laws. And then, before we even jump into it, for any organization, and I speak from the CISO mindset, right? For any CISO, for any organization, it just becomes a mess. So many different laws are coming in, so many privacy regulations, so many cybersecurity laws, FTC saying something, SEC saying something, and then GDPR, CCPA. There is so much happening, right? And now how can we standardize around it and still be able to communicate effectively the reasonableness to the courts if there ever a litigation is, or if we kind of be in that situation? So with that said, Kirk, would you mind going over the evolution of cybersecurity law and kind of walk us through a few slides here?
Happy to. So as Chirag says, the cacophony of laws, both federal and state, are quite complex and have been evolving over the last 35 years-ish. So we take this timeline here, and I will say that a lot like Forrest Gump, my career intersects with a lot of these professionally over the years. So HIPAA passed in '96, but we were developing it. I actually was a lobbyist in the late '80s, early '90s for Nationwide, and had the pleasure of working on HIPAA. And HIPAA was about a lot of things, right? Mostly about data interchanges in the healthcare space. But the realization was that there was going to be a lot of data. We had to assure some level of privacy. And then really on top of the privacy, you had to provide security, because you can't have privacy without security. So when we were drafting HIPAA, and I had the pleasure of being part of the group that drafted the security parts of HIPAA, we didn't really know what the standard should be. So we used the term reasonable. And then we sort of punted it to the Health and Human Services to define what that would be in later regulations, which didn't come out almost for another decade. But the point is that we all most of us having been lawyers and went to law school, we all know how much our professors harped on reasonableness, particularly in tort law. Tort law seemed to be the most appropriate, so we struck on that concept. Fast forward another couple of years with the Gramm-Leach-Bliley Act of '99, which established among other things, financial service privacy and cybersecurity at a federal level. We did what most people do. We hearkened back to what came in the past, and we went back to HIPAA and said, let's use effectively the same outline here. And GLB became effectively the framework. And it really is, at the end of the day, we're not talking about it here, but it really is the Fair Information Practices, right? It's FIPS. It became notice. But again, back to, you can't have privacy without security. It was primarily a privacy statute with I'll call it a codicil that said you have to have reasonable security practices. Again, you've got FISMA, Sarbanes-Oxley, and O2, more of the same, perhaps a little more definition around what is required, but not much. And then came the FTC safeguards rule, which every federal financial regulator did a safeguards rule as part of the FFIC, which is the umbrella organization that all federal regulators, financial regulators, are part of. It's a consortium, basically, and they try to make sure that their regulations are relatively uniform in a specific space. Well, the FTC safeguards rule was the first one to hit the street, and it was good. And everybody else effectively adopted it through some sort of a Me Too process. Those of us who were practicing the space really went to town on it. It did define it a little better. Antony discussed briefly how the FTC helped to define through their enforcement actions what effectively became a common law sort of security and privacy practices through settlements, right? It's not the normal way. It's sort of stare decisis without court decisions, because most of these things are actually settled. As Antony also pointed out, there is a paucity of real decisions, legal decisions in this space. They're mostly settled out at some point in the process, but they are instructive for those of us who are practitioners as to what they require. Then along in 2006, I think because most of us who were practitioners were clamoring for some sort of standards in the space, because I worked at the time, I was effectively technology counsel for a Fortune 100 financial service company who interfaced with the Federal Reserve, the Office of Comptroller of the Currency, Office of Threat Supervision, SEC, FINRA, and they all basically were implementing the same law, Gramm-Leach-Bliley, but they were all implementing it and interpreting it differently. So a lot of us ask for, can we have a standard, a yardstick by which the regulators, frankly, could all come together and we could all agree that this is what we need to do today. Fast forward up through CERCIA at the end here, and everything in between. I mean, again, it's more slightly specific laws that either help define cybersecurity in a specific space, or create infrastructure such as CISA and CERCIA for fighting cybercrime. I'll say. Along the way, CIS, as Tony said, created their standards as well. But at the end of the day, none of this was very helpful collectively, because we didn't really know what reasonable security meant, and it was sort of in the eye of the beholder. I will say that in my mind, cybersecurity is an evolving standard. So reasonableness is evolving. What was required when I started doing this in the late 90s versus what is required today is entirely different. And so the one thing that Antony talked about that is really important to remember is it's about foreseeable risk. And foreseeable risk, again, is an evolving yardstick. What was reasonable 10 years ago is likely unreasonable today because the technology has evolved, gotten better, the risks have gotten worse, or different risks have appeared. And so, you could have been completely reasonable in 2015, and if you had done nothing to your program by today, 2025, it's very likely that you're unreasonable. And take encryption for an example. What was reasonable in 1999, which for a private company was almost impossible. There have been lots of iterations over the years with encryption. So as in 2025, we are literally on the dawn of, if not, we are in a requirement that if you're not sort of doing end-to-end encryption in your network and with your anybody you share data with, you're likely unreasonable. Next slide. This is a great slide showing the evolution of state comprehensive privacy laws since 2020, and most of us remember it was California that sort of set the stage and was the vanguard of this. I would argue today that we have a comprehensive. I know there are people that are constantly trying to get a federal comprehensive privacy law. I think the die is sort of cast, very similar to state breach notification laws. They are generally similar. More of them are alike than dissimilar. The main thing for our discussion today is, as I said earlier, they deal primarily with privacy, right? The sharing and the use of personal information, sensitive information. And you cannot have privacy without security. It's impossible. Access controls in particular. And so every one of these state comprehensive privacy laws, and there are 19, and they're the ones in orange are the ones that are sort of still in play. They all, and there are 19 that have passed, and then there's a couple in green that are actually health privacy laws. They all require you to have reasonable security to safeguard data, to safeguard the privacy of data. So why this slide is important, again, is to establish, again, that this kind of growing consensus from the federal law, and I like the way that Antony talked about it in looking at it sort of strategically and then tactically and operationally. And if you look at the federal law as sort of being more strategic and it's obviously sectoral, this is where you get a lot of your things that you have to do from an operational perspective. This is where the shoe leather meets the road. In addition to these comprehensive laws, let me just state that state breach laws certainly are law. I call them negative security laws, because if you lose data, the only way you can stop or mitigate losing data and having breaches is to have security. Unfair and deceptive statutes that are overseen by the attorney generals come into play here in a very similar way to the FTC. And then the next dawn of this is really what the Ohio Data Protection Act did in 2017, 2016, and taking the concept of reasonable security to an operational level and defining it a lot more. Next slide. So I had the pleasure of working for an attorney general at the time, now governor, Mike DeWine, who was very frustrated with the proliferation of breaches in the late aughts, teens, early teens of the 21st century. And he felt that that a lot of businesses, particularly small and medium-sized businesses, were unfairly becoming victims twice. First, by being attacked successfully. Second, by having attorneys generals and other regulators kind of plague them and effectively hound them into settlements, costly settlements. And he did not feel that there was enough guidance from government to help business in general, but small businesses in particular, define what are the sort of the minimum best practices that you have to do to be considered reasonable or not negligent. I had the pleasure of being appointed to the CyberOhio Advisory Board and was made chairman of that. So concurrent with this, I will give a little personal story. My company, Nationwide Insurance, had a breach in 2010, and we ended up netting out a 38 state AG multi-state, which for anybody who's ever fought one attorney general is bad. When you're fighting 38 attorney generals, it's almost catastrophic. Now, they were alleging, among other things, that we were negligent, right? Unreasonable. And I knew, practically speaking, we were mapped to NIST, we were mapped to CIS, we followed HIPAA, we had active regulation under HIPAA, Gramm-Leach-Bliley, and I had regulators in my building literally 52 weeks a year, and they checked and doing technology exams. And you're never perfect, right? So perfection is not the standard here. Reasonableness is the standard. And so we fought this multi-state for 5 years and ended up with a very good settlement that was fair for us. But one of the things along the way was, I kept asking myself, what more could we have done? How could we be spending literally $100 million a year on cybersecurity, which is about what we were spending, somewhere between 90 and 100. And all of these controls that we had, and this one control failed because we missed a patch on 4 servers out of the tens of thousands of servers we had. How could that be considered negligence, right? And so Governor DeWine asked us to solve that effective problem. And what we came up with was a fairly simple model, which became the Ohio Data Protection Act, which, it said, and it did harken back to Gramm-Leach-Bliley and HIPAA and other things. And it said that you have to have a program, a cybersecurity program, but it's scaled to the size and complexity of your organization. You have to have a program that comports with the activities of your company. So if you share a lot of data with third parties, you're going to be held to a higher standard than if you don't, right? Those sort of things. Sensitive data must be protected more than, non-sensitive data. But the thing, when we started thinking about like what were the standards, and I went back to, and there was a lot of really smart people on my committee with me too, who were in the same boat. We said, well, we all harken back to, like we have NIST, and NIST is basically an open source standard that evolves over time, that the regulators do generally map their regulations to. CIS is something that we all use as a either primary or a supplement to NIST. If you're an international company, you do tend to use ISO in the mix as well. And so, nobody was comfortable giving the Attorney General or anybody rulemaking authority to create a standard. So what we did is we defaulted to the standards that were known and that worked and that were respected, and we cited them in a law. It ultimately became law. And it was one of Governor Kasich's last bills that he signed before Governor DeWine became Governor DeWine. And so that little law says that if you conform with one of these standards, we use conform because compliance, again, it's hard to prove compliance. Again, reasonable minds. And back to size and complexity too. If you conform to one of these standards, then you can get potentially a safe harbor from any lawsuits in the state of Ohio. And it does require, as everybody has pointed out ad nauseum, and we knew it going in, there would have to be a fairly serious pre-trial hearing to determine by a judge whether or not the preponderance of the evidence show that you were conforming generally with the standard and that you had a mistake or an error that led to some event that was outside of your control. So because of that, right, there have been several other states that have taken that law and either, in the case of Iowa, passed a fairly similar law, or Connecticut, Utah, and Nevada, which took the law, the safe harbor concept, mapped over to the standards with slightly different sort of safe harbor provisions in them. And there have been, as you can see here, West Virginia and Massachusetts are currently considering a version of the Ohio Data Protection Act as well. There have been several states that have passed it or almost passed it. Florida actually passed it, and Governor DeSantis, for whatever reason, vetoed it last year. There have been about 4 or 5 other states that have taken it up and got it pretty far through the process over the years. But I do believe that it is one of the best ways, again, of mapping back to known standards that everybody can kind of agree to and that evolve over time, back to that foreseeability issue. And really helping you and those of us who are legal practitioners or operational practitioners working together, help us define what is actually reasonable, what meets that standard of care that Antony talked about in his part. And I've already covered these. These are effectively, for those of you on the in the audience, those are effectively the outline of what these data protections statutes require.
If I could just interrupt for a moment. For attorneys seeking CLE credit, the code word is the word CARE. CARE. Additionally, there's 3 people that are participating. If you are attorneys and your name does not appear on the screen, if you could just let me know in the email how you participated so that I can issue credit to you, I would appreciate it. And once again, the code word is CARE, CARE. Thank you.
Thank you, Lisa. And thank you, Kirk, for going over the evolution and all these different laws that are coming in and the states leading the way. So, we talked about duty of care, standard of care. We talked about how this legal landscape is evolving. Now, one of the things which, Kirk talked about was to meet the reasonableness, you have to have a program. Now, to have a program, that's a very, very, in my view, very wide question. It's not easy to have a program. If you end up in court and you need to show reasonableness, you need to show the program, and the program has to have some basis. And for a lot of organizations that are heavily regulated, and even if they're not regulated, they need to identify what should be the basis of that program. And that question, we have answered as a CISO, specifically from my end, have answered for multiple organizations. And the idea is, as Kirk mentioned, if you are an international organization, you would base it on ISO standards. If you need a certification or so forth. If you are US based, somewhat related to the government entity or not, you have good amount of funding, you would go with NIST. Whereas CIS to me is the sweetest spot. You are a very small organization and you want a program, you got CIS. If you are a large organization and you want to have a good solid program before you can meet a bigger one through NIST or so forth, CIS kind of is a place which would give you a program that would meet the critical security, requirements. And that's kind of the name of the framework as well, CIS, critical security controls. So any organization where I have worked as a CISO, or I have mentored other CISOs, or I have done consulting work, I do multiple CIS assessments every year. And the idea is the program is always evolving, right? To monitor the program, you need to keep checking on what is there in the control and how the control is shifting. But to understand the controls is a very big task. Overall, understanding the controls and then implementing a program and meeting the reasonableness is the actual goal, right? So from there, let's first focus on a little bit. I will touch upon why I shared all of this a little bit later, but I first would want to pass on to Tony to talk about the CIS ecosystem, not just the controls, the ecosystem. There is beyond, like, just controls is not the only thing CIS is offering to help you meet reasonableness. There is a benchmark side also, which I'm truly a fan of, because to have CIS benchmarks implemented, it actually solves a lot in terms of establishing for the controls and establishing the program. So with that said, Tony, I would pass it on to you. We would give you like quick 5 minutes to cover the entire ecosystem, but
Sure.
please go ahead. Thank you.
I'll be quick, and thank you for the shout out, Chirag. It's great to be a part of this, and thanks. Yeah, just a couple of quick thoughts going back to our friend Kirk and what he talked about Ohio. Two brilliant things I think they did. That one is the pointing to existing standards to recognize. I've always said the challenge in cybersecurity is never about adding more things you could do to make yourself a little bit better. Cybersecurity is always a prioritization challenge, and you want to have an understanding of what bad guys are doing, what do you have at risk, and have a program to pull that together. So using existing standards, you don't need to create a new one. But everything that's been said can be said. This industry has been said over and over again. People just have to say it in different ways. So that's tremendously important. And then second is you need to think of this not as a security pass-fail test. The industry is full of those. What you need to know is what is reasonable? Where are you in the security improvement program? And it's going to change constantly, as everyone has said. And therefore, it's not a question of have I reached some magical state and now I'm safe. It's how am I making decisions all along the way? And that's why we've been very supportive of this entire activity around reasonable cybersecurity. We also shifted our thinking at CIS, and that's the diagram you see here. We're not producing a list of things to do on stone tablets that'll never change. We consciously see ourselves as part of a large ecosystem of security improvement and management and reporting and sharing. So to recognize, there are security frameworks by the dozens in this industry. You could make yourself crazy just trying to keep track of them and figure out how they should interact. But most were designed as a one-off for a particular purpose. We see ourselves differently. And if you look at this diagram, you see the controls in the middle. And that critical is chosen carefully, right, around prioritization. You can't do everything that's in a giant security catalog. You have to make choices. What is the most important set of things to do? But our goal is to answer the questions that go around the center of this diagram. So how do I know what you're telling me is going to be effective? How do I compare myself to others? How do I measure where I am? What are the resources to help me? Over the last several years, we've created an entire ecosystem of these products that you see in the boxes around the diagram here to help our adopters answer those questions. And a key part of that is how does this work that you're asking me to do in CIS relate to these other frameworks? Antony hit a really important point in there. He talked about his, I think, tripart. There's a sort of a strategic layer, there's a governance layer, there's a controls or a technology layer. That's absolutely right. And we recognize that, and we've designed our guidance, our recommendations to be conscious of that. In fact, I think we're the only security framework advisory, guidance group in the industry that we produce mappings from everything we do to everything else. So if as Chirag suggested, you might use the controls as a technology-oriented strategic roadmap. How do I get started? How do I start planning? But your boss wants to know how you're doing relative to NIST CSF. We provide a mapping to you, and we produce that so you don't have to. We produce the mappings to ISO 27001, to HIPAA, to PCI, to all these other frameworks, because we see ourselves as part of this ecosystem, and we know that almost anyone who adopts us has to deal with more than one security framework. In fact, many folks that we deal with have to deal with 2, 3, 5 or more security frameworks, depending on where you are and what kind of data you handle. So this notion of an ecosystem, this notion of how do we interact, how do we relate to these other frameworks is just built into what we do. And I won't go through the details, but all this is available to you, really at no charge from cisecurity.org. Next slide, Chirag, and then I'll wrap up a couple of quick thoughts for you. And there was a talk about, security frameworks are not static, right? The problem, what is reasonable, is not static. Here's a key thing that we have done. I think many folks do not know this story, but the Verizon DBIR, the Data Breach Investigations Report, is the closest thing we have to a singular authoritative statement of what's gone wrong out in the industry during the last years. And the Verizon data breach folks do a great job of collecting data from dozens of sources, including us, the kinds of attacks, how they were executed, what was lost, and all that. And they produce this DBIR. And if you read one thing in this industry in a year, that might be the thing to read because it's fascinating. But most enterprises, especially small, medium ones, cannot make sense of it. It's a great read, but you read something like that not to be entertained, but to decide what to do. What do I do about this? And if you look at the left column here, you see these are the key top-level findings in Verizon. What have we seen in the last year? Credential abuse, ransomware, et cetera. And we have worked now for, I think, 11 or 12 years now with Verizon, directly in the draft one of their report to map what they have seen into the controls. And you can get all the gory details of this in the report. But the idea is the reason you read reports like this is you want to translate them into action. If there's one verb I want you to remember about CIS, it's translate. People think the key verb in cybersecurity is share. If we would all just share everything we know, we'd all be really smart, right? We'd make great decisions. That's nonsense. Because most of this information is esoteric, it's hard to understand. The key verb is how do you translate it into positive, constructive action? So if you think of CIS, think the verb translate. That's our sort of conceptual model. We translate that into action. All this understanding about trade, craft of bad guys, threats, technology, et cetera, into specific things that, as Chirag and others have mentioned, allow you to build a security improvement program. And again, the gory details of this available to the public. We call this the community defense model. That is, we don't all have to defend ourselves. We have to think of ourselves as a community that's trying to defend each other, ourselves, but also the community as a whole. Next slide, please. And Chirag, I didn't know if you want me to go through some of this or if, in the interest of time, I don't want to.
I think keep going. I would cover the same thing. So please, Tony, go ahead.
Sure. I'll just mention a couple of things. Again, we have seen ourselves and reframed our work to be part of an ecosystem. And if you think of security as not a mythical end state, but a managed process over time, then you need tools to manage that. How am I doing? And how do I convey that to others? So and we work closely with the marketplace to sort of take our work and get it embedded in all kinds of tools, from technology scanning tools to GRC tools and everything in between. But we also provide tools to those who cannot afford them otherwise. And so the self-assessment tool, CSAT, it's a bit of a geeky acronym, but it's a way for an institution at very low cost or no cost to assess where they are in cybersecurity against our recommendations and be able to manage that, report on it, share it with others, give it to their boss, have it link up to the NIST cybersecurity framework and other frameworks. So again, this is provided to the public, and as part of our membership also that we use to interact in a business way with our adopters. Next slide, please. And again, it allows you to track all this. Think of it as a low-end GRC tool. There's an unspoken secret in this industry. The universal cybersecurity tool is something called Excel. All these frameworks and mappings and progress and who's assigned and what tool am I using, frankly, is being managed by Stone Age tools, spreadsheets. And this gives you one step up in a way that manages also, but also allows you to convey the results to others. But there's a whole marketplace of governance tools that allow you to do this at a much more sophisticated level, but we provide tooling for those that wouldn't have otherwise means to do it. Next, please. And this is just a sample of the outputs here. The colored boxes are about the top level of the CIS critical security controls, and the little spider web diagram shows that kind of where you are against each of them, but also how you're improving over time. And it gives you a sense of progress, It gives you a sense of a way to report, boss, here we're doing well. The idea was to provide a tool for that discussion between, for example, executives and technologists to say, we're doing well in some areas, but boss, we need support to improve in these areas. Let us show you how we're doing. Let us show you how we're doing relative to peer organizations. And that, we're conscious of I'll call it behavioral economics, right? At the end of the day, these are about incentives. These are about decision making, putting risk in a broader context. And again, back to Kirk and the work in Ohio, the goal is not about mythical technology security perfection. It's about what is the incentive to invest in better security? How do I provide the public policy levers that make sense for business executives to look at cyber risk in the same context they look at things like reputational risk, financial risk, personnel risk, and so forth. One more slide, please.
So, Tony, we go into the next slide. I want to add something
Please,
here.
of course.
Thank you. Thank you. So this, as I said, I do a lot of CIS engagements, a lot of CIS like controls assessments. One of the things that has helped, and I feel that may even help more in terms of reasonableness, meeting that benchmark, is where you see in the spider web, there is a purple line, like purple web, that is industry average. So over the last 5-6 years, CIS launched this product in 2019. Right. And since then, thousands and thousands of organizations that have done their assessment, all of that data is there in this. So even if you go to Big Four, different consulting companies, and a lot of times I'm talking to senior leadership boards, they do not want that how they are doing. What they want to know really is how they are doing against their industry. Right? Exactly. If you are in front of a retail board, the board wants to know that, okay, if I am doing this, what's the other retailer who I'm competing with is doing? Tell me that, and I will tell you if I need to spend more money or more budget or more resources and so forth. So I feel that the courts are also they can also see this as kind of a reference, in my view, for meeting the reasonableness kind of.
Yeah, Chirag, you're exactly right. There's a phrase I use. No one wants to be the lonely antelope at the edge of the cyber herd, right? And that was a shock to me when I left government. That was the most frequent question I got when I visited a number of Wall Street firms. They just wanted to know, how much is my competitor spending?
Yeah.
And and you could say as a security pro, you say, oh, that's the wrong question. But you could also say, as a business person, right, thinking of the incentives and economics, that is the correct question. And therefore, because you're now, if you spend more than you need to, you're putting yourself deliberately at competitive disadvantage. So providing the tools to begin both measure yourself and, you're absolutely right. This notion of a basis for comparison is a strong incentive to get people's attention. So absolutely, I think that's quite a good point.
Definitely. So go ahead, Tony.
And I'll just say,
around the benchmarks.
As you said, that we first put this out to the public just a few years ago, and that has allowed us. I mean, the response has been astounding, and so we sort of hit a need here. But it also gave us the opportunity to interact with lots of companies, see how they were using the recommendations, our tooling, but also to see their problem areas. So a big part of our focus at CIS is getting feedback to say, we want to provide recommendations that can and will be implemented. And the only way you know that is by getting feedback from others, right? Did we write these things in a way that makes sense? Is it possible to do this with sort of today's procedures, today's tooling, today's oversight and governance? And so we're really conscious of sort of building that. I will just briefly hint, there's a question that popped up in the Q&A box around, but we don't own our IT. We do this through a service provider. That's why we added in the previous version of the controls, a service provider control, because so many people were starting to outsource their IT or their management services and so forth. We just had a couple of discussions in the last 2 or 3 days, though. This was going to be a big emphasis for the next generation of the controls. Yeah. So many, software as a service, cloud IT, through the cloud service providers. We're moving to a much different, we've already moved to, in large measure, to a really different model that's not the traditional buy my IT, configure it myself, operate it myself. And we really need to address that more specifically. So we'd love to hear your feedback. Reach out to the company, reach out to me, and we'll give you our thoughts and love to hear your feedback on that. Thank you.
Yeah, I will add with you can outsource your IT. You do not outsource your accountability.
Bingo. Absolutely. And therefore, you better be careful what you ask for when you outsource it.
Exactly.
That's the key, the discussion between the buyer and supplier of services is a critical one that we need folks like you and Anthony, to be. We got to ask the right questions so we get the right service so that we can explain it to the right regulator, for example, or to the court system or whatever. Thank you.
There was a question that came to us yesterday before the panel to kind of address during this time. So there is from Robert Patterson, he mentioned that they're developing agentic AI resource to enable board members to monitor their enterprise security duty of care. This work builds on their 20 plus years of experience with boards in the US and EU overseeing their fiduciary duty of stewardship. The platform assesses board actions related to the Gov section of the NIST 2.0 standards. So there's a bunch of other things, but the actual question is, how do panelists see the reasonable cybersecurity argument fitting with or complementing board level fiduciary duty as part of enterprise risk management as outlined by NIST? So I think I'll give you my view and then I'll pass it on to any other panelist who would like to add on top of it. As we mentioned, boards have their own responsibility. They want to know, they have to keep, monitoring the program. You have to keep doing board briefings. I have seen multiple senior leaderships, teams and boards. They want to know every quarter what's happening in terms of the program. As Kirk mentioned, it's always changing. It's dynamic, right? So there is no given time that you do an assessment and that's it, right? Against a framework, coming up with a report and showing this is where we stand. To start building the program, sure, but to have a program that's always evolving, and as Antony mentioned, the reasonableness standard also is like a moving standard, right? So from that perspective, where you see this product which you have built around meeting the duty of care requirement, my view is that if the product is collecting information and providing how the board is acting to it, that is one area which basically overall ecosystem, overall program framework, one aspect would be the fiduciary duty of the board, and that duty can be met with the agentic AI resource that you have built. So Robert, kudos to you for working on it. Good idea. I feel that boards would get good benefit out of it. But overall, having still a CIS assessment at the complete spider web, right? And evolving, having an assessment done, continuous assessment done, and then kind of using that as a moving reasonableness kind of a benchmark is, I think, the proper way for all of us to focus on maturing their programs. So with that said, any other questions, anybody? Otherwise, we are hitting 1 o'clock. I just want to be mindful of everyone's time. Any other questions?
I will simply, there was another question about, does this apply if you're a solo practitioner? My answer would be yes, but back to size and complexity, you probably if you configure, if you're working off of a Google Suite or MS or Microsoft 0365, make sure you've enabled all of your controls and that you practice good password hygiene and have multi-factor authentication. And so you probably are already paying for all the controls you need through whatever service you use as your office production. That would include also your, make sure your Wi-Fi router has a strong password on it, and make sure your printers, and make sure your software is always up to date.
Yeah. So just to add a little bit on top of it, I think if you look at the CIS framework, implementation group 1, 2, and 3, focus on the implementation group 1 to start with. If you're a solo practitioner, that's where you start. Then you go towards IG2 and IG3, but IG1 is what actually Kirk covered. I would highly recommend that you go with the IG1 as quickly as possible. Yeah. Anybody else? Anything? All right, passing it back to Tom for closing. Thank you, everybody.
Thank you.
Thanks, Chirag. And thank you to Tony and Kirk and Antony as well for your deep expertise on this topic. I want to ask our attendees once again to please complete the evaluation form and get your CLE If applicable, get your CLE documentation into Lisa Rivage within 24 hours. I want to thank you for spending an hour of your day with us. And with that, that concludes today's CLE. Bye, everyone.
Thanks, everybody. Bye. Thank you.